All right, good afternoon. Welcome to the last hearing for today. We are so honored to have members of our co-equal branch of government here with Justice Kevin Doherty and Justice Kevin Brobson, who are before this committee representing the Judiciary. As I stated before, I want to remind everyone this is our co-equal branch of government, and we will conduct ourselves and treat them as such. Before we begin, I would like to see if Chairman Struzzi has any introductory comments.
Yes, thank you, Chairman Harris. Good afternoon. Thank you for being here. To set the stage, the governor is proposing a total general fund spending amount of $50.2 million for the judiciary in this current budget proposal for fiscal year 2026-2027, an increase of $46.7 million, or about 10.3% over the current fiscal year. And it should also be noted that you also receive some funding for revenue from court fees. And with that, we can move forward with the questions. Thank you.
Thank you. Before we start, members, let's make sure our questions are budgetary or even policy-based. Let's remember that the justices will not be able to answer questions about cases that might be before them or to opine on how they feel on different issues that could come before them. As much as we may like to know those answers, they will not be able to answer those type of questions this afternoon. I want to remind everyone that our timekeeper is in the middle of the table. When our members start, they will have 5 minutes to ask questions. The light will turn green. Then there will be 30 seconds. That light will turn yellow. And then at the red light, we ask that you would conclude with your comments. Okay. All right. That's kind of weird, but before we start, if we could have the justices and the staff stand so we can swear you in. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, so help you God? Thank you. Justice Doherty, Justice Brobson, if you wanted to do any introductory comments, but also, please, any other jurists that you have with you today, if you could please introduce them to the committee as well.
First and foremost, good afternoon, everyone. Chairman Harris and Struzzi, Judiciary Chairmans Briggs and Kaufman, and members of the Appropriation Committee, thank you for this opportunity for us to appear today. As you heard, I'm Kevin Doherty, and beside me is my colleague, Justice Kevin Brobson, and the Court Administrator, Andrea Tuominen. First, we want to recognize the members of the expeditious bipartisan passage of House Bill 331. This incredible, needed modification to our judicial computer system account funding formula was for this year as well as the next 2 fiscal years. This change will deliver an additional monies to offset the steady decline in account revenues since 2008. This aligns with the recommendations by your created JCS Financial Audit Committee back in 2022, which specifically requested, quote unquote, to ensure predictable funding to support the system's continued operation. But I'd like to share from our heart a special thank you to Chairman Briggs for offering this amendment and all the members for your unanimous support of this subsequent passage. I'm here today because we need your help. The judiciary, we on the Supreme Court, we have 3 revenue components. There is a general fund line item. Then we have Act 49, which has been created through fees and costs and fines to supplement the need to fill in shortages on our general fund. And then we have the exclusive juvenile computer system account, which is statutory fines and fees specifically used exclusively for our computer system. Your Act 1 of 2026, the $7.5 million supplement, went to that so that that computer system would remain. Otherwise, we were potentially looking at a loss of over $350,000, 350,000 people using our information. Was that it correct? Was it?
It's upwards of that, Justice, yes.
Okay. Here's our concern. Our general appropriation amount has been augmented by Act 49 funds for quite a substantial period of time. While Act 49 was intended and has been used to supplement the general funding of the judicial branch, the account balance at the end of 2024-25 was only $17 million. It's estimated that the amount will be $8.2 million come June 30th, 2026. The reason for this marked decrease is simple. If the judicial branches, if we do not receive our requested state appropriation, the more we need to rely on Act 49. As the Act 49 balance decreases, it limits the amount of funds that can be applied. This continued use of Act 49 has a detrimental tumbling effect on our subsequent budgets, requiring higher state funding requests to address significant cost drivers, which could be our statutory COLAs, increasing health care costs, budget deficits, and obviously a continued decrease of Act 49. While this is a problem for the entirety of the judicial budget, it's especially acute at those levels most impactful to your constituents, our county-based common pleas courts and magisterial district judges. I have to tell you, court operations just for CP and MDJ eat up approximately 75% of our budget. We take our role seriously for that which we have, and that is particularly when we're talking about magisterial district judges. Every 10 years, we review current and future judicial needs. This ensures each judicial district has the correct number of judges to manage cases and provide our access to justice. As we sit here today, there are currently 11 vacancies on the MDJs. This process allows the court to competently and efficiently meet the needs of whether we are reestablishing, realigning, and when appropriate, eliminating district seats. I must share with you, we on the Supreme Court do not find it helpful when we have to remove judges in magisterial district courts, which really, for many of our rural counties, is the initial and first contact with the judicial system. Our common pleas court complement, that's strictly a legislative function, and the judiciary respects your prerogatives. However, I must share with you, since 2017, 2 legislative enactments have made 19 new judgeships. Those new positions represent a $6.5 million annual impact on our budget. A cause of our concern is that we had a 5 fiscal years followed the 2017 enactment where the CP line was flat funded. For example, this year, 9 new common pleas court judges took seats for full term. Our common pleas court line item was funded at $6.7 million below the amount to fully fund the complement. We're asking you, our Article 3 brother branch of government, to ensure that the full amount and fair funding for Article 5, the common pleas and magisterial district judges lines, are met. When you look at the amount of unfunded positions, what that equals is close to 25 common pleas court judges, and including 7 MDJs. We, like you, are not program-based. 90% of our costs go to personnel. We, like you, are funded with less than 1% of the entire state budget. We do believe that we are good stewards of the fiscal, of the public's fisc. When we can, we try to save as much money for the taxpayer and for the Commonwealth. For example, in our Office of Children and Family Court, created by former Chief Justice Max Baer, we have been able to reduce child welfare placements by 11,000 over the last 15 years. When you look at the cost, I cannot say that we're saving, but I can say as a result of court involvement and our sweat equity, we've saved, or I should say, our child welfare budget would have increased an additional $48 million. It's an intangible. It's the right thing to do, protecting our most at-risk and vulnerable children. But it's also an indication of the Supreme Court and our judiciary working hand in glove with you, with what has been given to us, to make sure that we do the best that we can. However, we're not able to continue to function like this. To more accurately align Act 49 with the actual revenue that we are receiving, I'm here today to respectfully seek $64 million in additional state funds, which includes full judicial complement and other necessary operational increases, such as cybersecurity and the use of our JNet. The judiciary also respectfully requests that you consider repealing the statutory provision diverting $15 million from our JCS funds. The current suspension will expire on June 30th, 2026. Our concern is that if we are to continue helping our sister parts of government, that being the executive and you and the General Assembly, and more so, the good citizens of the Commonwealth of Pennsylvania, we need you to help support us efficiently. Our concern is, and I've listened to some other individuals testify, when you look at offices that are protecting the public, and we're trying to make sure that our children and our families can live peacefully in Pennsylvania, we understand that they need funding to maintain their program. But law enforcement is no good if we don't have a court system to make sure that we can separate the good one who got caught up in a bad way by putting the bad person away and never apologizing for either. I sit here, I ask you, as my colleagues, please consider the judiciary as your friend and partner. We are present for questions.
Thank the Justice. And let's go directly to Representative Fleming.
Thank you, Justice Doherty, Justice Brobson, Andrea. It's wonderful to have you here. My question is going to be around the schedule of the court in terms of your decision-making. Nerds like me who follow the United States Supreme Court understand that the court has 2 seasons essentially every year where they hear oral arguments. They decide what cases they will hear in that particular session, and then they rule at the end of that session, usually in July or December of their separate oral argument sessions. And I was wondering what the schedule is for the Pennsylvania Supreme Court. You know, I know there are cases that you hear in prior years that you can still rule on, and so I'm just trying to get a sense of, you know, on average, how long does it take before you hear oral arguments on a case until you finally make a ruling as a body?
Well, we have internal operating procedures that we try to apply, but the reality is that there are 7 of us. And what happens is each of us will come back after we have met after a session. We have decided who may make a majority or who may be in the dissent. What really happens is then we go back to our individual chambers and we start crafting our own writing. Now, we wait to see those who have been assigned by the Chief Justice the majority opinion, and we wait to see if we agree with that. So the process of writing and reading and writing and amending and writing, because I share with you, if you were the author of an opinion and I'm in the dissent, I write the dissent, you're going to respond to my dissent. Now I have to respond to your amendment. Depending upon the extent of that issue and the substance of that issue, it could take anywhere from, what would you say, Justice?
Every case is unique.
Sure.
Yeah.
Multiple cases involving multiple issues are more difficult. Certainly, I think the justices on the court strive to get opinions out as quickly as possible after submission, and what I define as submission is either after oral argument or after we've decided we were not going to have oral argument. I think it's important for us to get it right, not just get it fast.
Sure.
And I can tell you, operating any enterprise with 7 CEOs can be can be challenging sometimes. We do the best we can.
Yeah, and I understand the nature of, you know, the difficulty, especially, as you said, the more complex the issue, you know, the more time it may take. But I just wanted to ask that and make that contrast between, like, you know, folks like me who see the way the United States Supreme Court operates, where it's like boom, 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 one session, all your oral arguments, all your cases, all your decisions, as opposed to the way the Pennsylvania Supreme Court operates. I do have to say in closing that I have seen the court operate in person in oral arguments on a couple of occasions, and it is rather impressive. So I want to thank you for what you do. Thank you for how you serve this Commonwealth. Thank you so much, Mr. Chairman.
Thank you.
Thank you.
Thank the gentleman, Representative Nelson.
Thank you, Mr. Chair, and welcome, justices. It's great to see you here again. I wanted to start our line of questioning in the area of what we used to call problem-solving courts, or now treatment courts, potentially. Earlier in your opening remarks, you talked about additional funding or the need for funding in the broader picture. When we've discussed these treatment courts now, and that's drug courts, mental health courts, domestic violence, veterans courts, they've been very successful in the counties. I think this budget calls for an increase in funding, about $77,000, not a whole lot, about 5% for that line item. Can you touch on your perspective of these courts? You know, do we have performance standards to measure how effective they are?
I'd be happy to talk about treatment courts for as long as you let me do it. These are incredible programs run in our counties that are not just changing lives, but they're literally saving lives. So I'm so appreciative of the judges that are spending their time to work in our drug and alcohol, our DUI courts, mental health courts, behavioral health courts, and let's also not forget about our veterans courts that are doing so much to help the men and women who've served our country and put themselves in harm's way. These provide an amazing second chance opportunity. In terms of efficacy, I know that we have had a year-over-year improvement of graduation rates from our courts. I think the year-over-year improvement from 2024 to 2025 was about 4%. So when I'm talking about 4%, I'm talking about graduation rates. We talk about graduation rates between 60 and 80%. That's 60 to 80% of those people that are not going to be incarcerated. So the programs are doing a marvelous thing. We've just launched our certification programs this year. We have treatment court champion courts that have been stood up as part of our certification for our drug and DUI courts. Happy to talk about and do a shout out to Judge Boylan in Bucks County, Judge Geishauser in Berks County, Judge O'Neill in Montgomery County, and Judge Sklarowski in Luzerne County for stepping up and being our champion courts for our certification program. We're looking to roll it out on certification this year for drug and DUI, next year for our mental health and our veterans courts. But we will take as much financial support from the General Assembly and the Governor as you're willing to give us to send these important grant monies back to our treatment courts to provide them the resources that they need to do the amazing work that they're doing. So we thank you for your support.
Yeah, those funds do seem to be quite effective. I know Westmoreland County, our drug treatment court, is now on their 22nd or 23rd class. They've had over 100 graduates. It's one of our most successful programs to keep people straight, working, and we've expanded over into those veterans courts. But really, our judges do that on their lunch break, you know, in addition to, so I was kind of surprised that, you know, that 77,000 seems a little bit low for the amount of bang we're getting for that buck.
Yeah, Representative Nelson, I've been here a couple of years now talking about the treatment courts and been out there, and we could use so much more money in that line item. But as Justice Doherty noted, we have line items right now that are not fully funding our constitutional complement of common pleas court judges.
Sure.
As much as I would like to be here being able to ask for the well-needed and ROI funds for treatment courts, because I believe there's a high ROI, our exigency right now is getting our complements fully funded, funding all the positions that you all have created.
Then shifting gears a little bit, it's somewhat of a specialty court, but in the area of mental health. We talked last appropriations hearing, the Behavioral Health Commission, and Westmoreland County, there is a big delay and sometimes extending up time that somebody is in prison because they're waiting for those mental health evaluations. I know the Judiciary created the Office of Behavioral Health, and there were meetings through the state were there some key findings that we can help better address the behavioral health issue that we're finding in our prisons and in our courts? I think, Andrea, that may be...
Yeah, you want me to take it? Thank you, Representative, for that question. I mean, some of the key findings coming out of our statewide summit, and we just held 7 regional summits. There are judicially led regional councils across the Commonwealth that are partnering with local government, our county executive, and other stakeholders in the county. And a lot of the themes that we heard in our statewide summit were sort of repeated in these regional summits, which is, we really need to build crisis infrastructure in our Commonwealth so that there is a continuum of care for these individuals that are struggling with mental health. There is a need to address competency assessments, and a number of jurisdictions are doing that. In Montgomery County, Judge Gail Walheimer established really a groundbreaking competency docket program that is now being replicated in areas across the Commonwealth, including, I think, Westmoreland is looking at that. And in Crawford County, they have stood that up as well. So what that will do is sort of focus the resources on expediting these assessments so that the person doesn't decompensate while sitting in jail.
Great. Thank you, judges. Thank you, Mr. Chair.
Thank the gentleman. Representative Kincaid.
Thank you, Mr. Chairman. Thank you for being here today. I wanted to talk about a little bit about sort of internal court policy. We're seeing more people experiencing a chilling effect as we're seeing federal crackdowns on immigration, and so people who are afraid to come to courthouses that they might be picked up for immigration, even if they're lawfully in the United States. So coming as witnesses, reporting crimes, especially like domestic violence, or otherwise seeking relief before the courts. Does the judiciary have a policy to allow folks to participate virtually, and is that something that is universally accessible, or could it be in cases like this?
The answer of that is, has it been used? We used it during the pandemic. But the reality is it's not good practice. So I would say the answer should be no. The fact is that you need to come in. If you're dealing with people's lives, while we're concerned and we consider the fact that it may be convenient or easy to do virtual. The reality is when someone's livelihood or wages or home is on the line with the decision of a judge, it is much better for the judge to see that person so we can judge their character as to whether they're telling the truth or not. Just those intangibles that are essential to dispensing equal justice.
Yeah, I appreciate that. As somebody who I share a parking lot with a magistrate judge, and we've seen a number of folks who are trying to access the courts be picked up before they are even able to enter the building. I think that's something that the courts really need to consider in terms of access to justice for those individuals. I want to turn a little bit to IOLTA. So the IOLTA rules prohibit organizations that it funds from receiving more than 50% of their funding from a statutory source, like court appointments as counsel. But we as the legislature have talked a lot about the right to counsel and expanding it beyond the criminal realm. So in that case, if we are doing that for landlord-tenant cases or civil cases, is the judiciary considering amending those rules, or would they, in order to ensure that bar foundations, legal aid services, and others are still eligible for IOLTA funding if we as the legislature would expand the right to counsel?
This, this is the first I've heard of this as a possibility. Certainly, we as a court often react to things that the General Assembly does from a policy perspective. You know, for example, when clean state legislation was passed, the Judiciary took steps to implement the clean slate legislation. If the General Assembly were to do something along the lines of what you're saying, I have no reason to believe why we wouldn't re-examine the rule. I certainly can't tell you what the result would be, and maybe Andrea knows more about the rule there than I do, but I don't see why we wouldn't at least look into it if that was something the General Assembly did. Andrea?
I would just like to clarify, because I think this goes to a point that you made, that the Pennsylvania Legal Aid Network receives the largest grant from the IALTA board currently to facilitate the statewide delivery of civil legal services throughout its 70 local offices across the state, and every county has a planned legal aid office. Last year, I asked staff, and staff reported that the planned network delivered free civil legal representation to over 80,000 households, reaching over 176,000 individuals, including over 74,000 children.
Thank you. I think that's fantastic, and I want to make sure that that continues to be available if we decide to expand the right to counsel. So thank you for being here. Thank you, Mr. Chairman.
Thank the gentlelady. Representative Krupa.
Good afternoon. Thank you all for being here and your willingness. I bet you this is the worst part of your job. So with that being said, and I say that with candor because I come from, I'm an attorney by trade. So I've been here for 3 years and sometimes it's very painful. But thank you, Mr. Chairman. I want to discuss your budget with respect to the potential legalization of marijuana. I want to initially note that I firmly believe that the idea of a net positive financial gain from legalizing marijuana is a fallacy. If you look to states like Colorado who've been down this road, studies indicate that for every dollar that's generated in taxpayer revenue, there is a cost to society that's over $4 in terms of heightened crimes, truancy, homelessness, addiction issues. It just goes on and on and on. I firmly believe that government should never attempt to profit from addiction. The proposal to legalize recreational marijuana raises serious concerns from families, for those in recovery, and for the young people who will inevitably see increased normalization and access to this drug. And it's interesting, we just had a very thoughtful conversation you did about our treatment courts. And the idea that this would become law just is going to add to the job security for everybody that is involved in managing those treatment courts. But today, as appropriate, our focus is on budget issues and how this would impact the budget of the judiciary. So the governor asserts that legalization would reduce cannabis-related adjudications in the judicial system and ease the burdens on the courts. Last year, however, testimony suggested there was no clear estimate of actual savings, and I would argue that that's because it's a fantasy. So in an effort to gain some clarity, what percentage of the judiciary's current caseload is attributed solely to adult marijuana possession?
I think those are statistics we may be able to run through our CPCMS system and get back to you after the hearing. I certainly don't have those stats off the top of my head.
Yeah, those stats would be county-based.
Okay, that would be great. So I'm assuming then you don't have any specific verified dollar amount that there would be a potential savings.
We Representative, I think we received a similar question to that last year.
You did.
So if I could just roll the tape back and just what we said last year, and hopefully not be inconsistent with that. We have not been asked about our position on what kind of savings there would be from legalization of marijuana. As we said last year, that certainly is a policy decision that would be made by the legislative and executive branch, reserving our role, if any, to any legal challenges to it.
If I may politely interrupt, you've not been asked by the governor's office, but I at least asked you last year.
You asked us, I think, again, I think you asked us if they asked us. And I think our answer was we were not asked in advance. And I'm not aware that we have been asked recently. We haven't looked at that. All I would say is if there are any costs associated with implementing any of that, that the legislature and the governor be considerate of any additional costs that would fall on the judiciary and make sure those are fully funded.
Okay. So in this, I don't believe that I asked this last year, but the current proposal includes automatic or immediate expungement of certain marijuana-related records. Do we have any idea what it would cost to modify the unified judicial computer system to process that expungements? Would this require additional personnel, overtime, or outside contracts?
Representative, this is not a hard number, but we do estimate that recoding, what automatic expungement for marijuana offenses is not the same as clean slate. So we would need to build something to facilitate that and involve the Pennsylvania State Police to ensure that all the necessary procedures are accounted for. We estimate that maybe at minimum it would cost $2 million. But again, that is, just based on experience with clean slate, and this would not be exactly analogous to clean slate. And so what AOPC would ask is that you continue to engage us as legislation is introduced and starts to move so that we can make sure that we work through those details.
And is it safe to assume that those figures, whatever ultimately they would end up being, are not calculated into the current budget proposals?
That's correct.
Okay. I just want to end in stating that before this body relies on any potentially projected marijuana revenue, that we do need a full accounting on real numbers of what this is going to cost the judiciary and our law enforcement. Thank you so much.
Thank the gentlelady. Representative Bellman.
Thank you, Chair, and thank you all for being here. In 2025, there were 446 incidents reported at common pleas courts and 451 at magisterial district courts. The governor's executive budget provides the judiciary with $2.8 million in state funding for unified judicial system security, a $654,000 increase over last year. Can you talk a little bit about how the funding is used and if you believe it is adequate to provide physical security to the common pleas or magisterial district courts?
Yes, sure. I think along the lines of what we said about treatment courts, of course, we could always use more money to ensure that our judges, court staff, and the people that enter the courthouse door are kept safe. We use a large percentage of approximately $2.6 million of that money in annual grants that go back to harden both the county courthouses and the magisterial district judge offices, a whole panoply of things that are protective measures to protect those judges and staff while they work in those areas. We also fund programs that help protect a judge's personal identifying information by being sold to data harvesters and sort of compiled in dossiers. We do a number of educational programs this year. I think last year we did a program on personal attacks on judges. This year we're going to be focusing on cyber security for judges and for courts. But as I said at the beginning, we could do so much more. I mean, the magisterial district judges in particular are, sitting in courts that are in strip malls. Or, I hate to say it, I think we've had a recent occasion where the building was deemed unsafe, and so the magisterial district court had to relocate. So those courts in particular don't have, except in certain locales where the county commissioners have decided to fund court security, those courts do not have armed security or magnetometers at their door.
Okay. And if I could share with you, 58 out of 67 counties throughout the Commonwealth of Pennsylvania have reported security incidents. It's very interesting. when I look at these numbers, we look at it and sometimes you forget that we're dealing with people's lives. Just this year, or just this past 2025, in Lebanon County, one of our judges on 2 occasions, on December 5th, a severed deer head was placed on her driveway. And then on December 31st, a dead pheasant was stuffed into her mailbox. Our president judge, who I happened to spend the last 25 years with on the bench, John Forador, had a death threat in Jefferson County. And then we just recently had another incident over in Bedford County in which a Facebook was life-threatening. It's different when you know these people. This is not just stats. These are friends of ours, friends of yours, and people need to take that into consideration. I find it far too easy that people dismiss judicial security threats because we always see it on TV somewhere else. It's happening in Pennsylvania, and it's happening to my friends.
Is there, real quick, is there anything else that you think that we can do legislatively to help with this?
I hate to sound like a broken record. You referenced the governor's proposal. I urge you to look at the Judiciary branch's proposal and fully fund the request that we made in our security line items, including our cybersecurity. I mean, cybersecurity is a big thing, as we all know. In your branch of government and the executive branch, we had a large state agency have a cyber attack within the last couple of years that not only affected the agency, but affected the administration of justice in the Commonwealth of Pennsylvania. The numbers that we have asked for are, in our view, necessary, and we'd ask that you fully fund them.
All right. Thank you all. Thank you, Chair.
Thank the gentleman. Representative Kutz.
Good to have you. I want to focus in on a couple of numbers, overall top-line budget numbers. So 25-26 fiscal year, the Judiciary received $453.4 in general fund appropriations. It's an increase of 4%. And then for 26-27, governor's proposed $500.2, which is a 10.3% increase. While the governor's overall general fund request is 5.4 over. So I'm curious the disparity in the increase there to 10.3 for Judiciary. What in your mind is driving that, the biggest drivers for your increase that's needed?
Representative, as you know, the Judiciary went through a 6-year period of flat funding. Our drivers are the same drivers that every other branch of government has. 90% of our budget is personnel driven. These are expenses that we can't control. A lot of the personnel, at least on a common pleas line item, is personnel that's authorized by the legislature and that we are constitutionally required to fund. The drivers of our budget are not different from the other drivers, except the fact, when I said it last year and I said it the year before, we are making up for a period of flat funding. On top of that, we have a number that we need to operate the Judiciary, which then gets supplemented by the Act 49 funds. In good years, Act 49 funds were able to fill some lower funding that we got in our general fund appropriation line items. Act 49 is coming close to a fiscal cliff. We're only projecting $60 million of available funds to supplement the state funding this year. So our budget request this year is based on the reality that we will only have $60 million to draw on from Act 49 funds.
Let me zero in on that Act 49. What can we do to counter that trend, or should we expect going forward as the Act 49 funds continue to go down that you'll just need more in general fund appropriations, or something we can do as a legislature to reverse that?
Well, I think our costs are going to continue to go up, just like everybody's costs are going to continue to go up. So in the Act 49 funds, yes, we anticipate a decline in the Act 49 funds available. What we'd ask that you could do is look at our budget this year, and if you have any questions about any specific line items that you think that our numbers are just completely out of whack, we'd love to have that discussion with you.
No, not at all. I think what I'm getting at is, there's the age-old principle that people should pay for the cost of their own administration with the court, right? So you're going to have state fees make up, X percentage, and general fund appropriations make up the rest of the percentage. So I guess what I'm curious about is, do you know comparatively to other states, whether we're on par with other states in terms of what percentage of judiciary funding comes from fees versus state appropriations?
I can't tell you whether other states are on par with us, and, you know, Act 49 makes up 12% of our general operating budget. What I can tell you is that the other states that have to rely on fees, whether in their general operating or for the entirety of their judicial computer system, yes, they are approaching the fiscal cliff just
Yeah.
like we are.
Well, and so here's the bottom line. Here's what we're after. We need a court system that recognizes those who are taking part in it should pay some part of the reason that they're there, while also recognizing that that can't be a barrier to justice and be a barrier to access for the legal system. People shouldn't have to pay exorbitant fees, and that's where we as the General Assembly have to ensure your appropriation keeps up with it so that people aren't burdened by court costs. At the same time, realizing that there is some level of responsibility that is borne for the repeat offender who keeps coming back to court, or, you know, for someone who needs to transfer whatever court documents you need. There have to be some sort of fees on it. So I think it's just finding that balancing act to ensure that our system can continue to operate fairly. And obviously it's a unique position the General Assembly is in to have the purse strings over the appropriation for the courts. And a responsibility I take very seriously is respecting the co-equal branch of government and making sure you have what you need to operate. And I'll wrap up with this as well. I appreciate your candor on personal security for judges. It's the same thing for members of the General Assembly and all the way down to school board members and township supervisors. And it's incumbent upon us and every member of this General Assembly to ensure that we fund personal security, that we ensure that our members of the court feel safe, that members who are elected feel safe, because if we don't, people will stop doing it. And when people stop participating, and you spoke about the vacancies we have in MDJ level, partly because people don't feel safe going into those strip malls where they're gonna have to be the first line of defense for those courts. So I appreciate the strides that you're making and would welcome a conversation to ensure your safety and the safety of everyone who sits on a bench and everyone who appears in a courtroom so that our system of justice can continue freely and uninhibited by those threats of violence. Thank you, Chairman, for the latitude.
Thank you. If I may say, Mr. Rep, thank you very much. Prior to me having this job, I was the administrative judge of a large family court system. And the greatest concern I had is exactly what you just articulated. How do we make sure that we have access to justice while not financially precluding access to justice? I fought 15 to 20 years in the Philadelphia system to do that. We have not been able to balance it. I look forward. I'm sure this court looks forward to having discussions with you and the people of your same mindset so that we can. You cannot price ourselves out of justice. And that's a concern that I have very much shared with you.
Thank you so much, Chairman. Appreciate the latitude for the conversation.
Thank the gentleman. Representative Rigby.
Thank you, Chairman. Thank you, judges, for being here. In looking over the budget, one of the increases that caught my attention was the Commission for Fairness and Justice. It's a $151,000 increase, which represents 42% for that line. Could you just tell me a little bit about the work that this office does and why it needs such a large percentage increase compared to other line items that you have in your budget?
The Commission on Fairness and Justice, formerly known as the Interbranch Commission for Racial, Gender, and Ethnic Fairness, if I recall correctly, was started over 2 decades ago. It is an interbranch commission. The governor, the General Assembly, and the Judiciary each have 8 appointees to the commission. I know that the work that they are doing sometimes dovetails with work that we are doing on language access and facilitating jury service. They have a website where they post it, but you know they're on our line item because they were put on our line item despite them being in an interbranch commission. And so much of what we do is we pass that money directly through to them. I believe the reason for their increase is largely personnel and maybe a small amount of operating with respect to their quarterly meetings.
Like I said, I just noticed it was a huge increase and wondered if what was moving forward, so thank you.
Representative Alsomer?
Thank you, Mr. Excuse me. Thank you, Mr. Chairman. Andrea and Justices, thank you for being here this afternoon. I have a question that involves cybersecurity. Last year at this hearing, when we discussed cybersecurity, it was mentioned that many of the computer systems for the lower courts are managed by county governments, and that the systems were coming under increasing cyber attacks. Could you please update us on this current situation?
The situation, Representative, remains the same. Those are county-based operations, so I think the vast majority of our courts are served by their county IT departments, which also serve the county commissioners and many other county agencies. I referenced earlier, and I think I mentioned this at the hearing last year, that we share that concern about increasing attacks. That is why we are hosting these 3 regional summits this spring for county court leadership to come together with county executive leadership. And we're asking president judges to set up 5-member teams that would be inclusive of county commissioners, county IT directors, so that they can discuss cybersecurity, the current landscape, and engage in a tabletop exercise. This is something that I brought back from a Mid-Atlantic Summit of Chief Justices and State Court Administrators. We found it, even though we have been through many cybersecurity education initiatives at the state level and penetration and vulnerability testing, you can never do enough. So I wanted to bring that experience back to our counties, courts, and county IT directors.
Just for my benefit, do the county courts connect to the state courts through a network or through?
Yes, I mean through our MDJ system, as well as through our Common Pleas system, which handles case management for both criminal and juvenile courts.
Right, so there's a network that connects, and I'm sure there's emails that go back and forth and other means of electronic communications, which ultimately means that the weakest link is the most susceptible way to infect the entire, which ultimately in the end means that we're all in this together. And if you have one county that isn't acting appropriately, it could essentially affect the statewide system. So,
yes, I'm sure one of the many things that we're going to highlight at these 3 regional summits, our court has really emphasized the need for cyber security education training at the state level. That's our appellate courts, appellate court staff, and AOPC. So we are now on sort of a regular cadence of education and simulated phishing attacks so that people are educated not to click on that link, not to enter in their personal information.
do you coordinate with the counties those kinds of phishing? Do you verify if the counties are doing those phishing activities at any level whatsoever?
No, those are, I mean, we are doing it, again, through these cybersecurity regional summits. I can tell you that we are regularly engaged with the County Commissioners Association of Pennsylvania discussing these matters, but these, in effect, are county-based operations.
Yeah, I mean, somebody that I've dealt with some cybersecurity myself, and I would say that if you're not engaging that's a potential area for real concern that you have, just kind of leaving the door open, in my opinion.
Well, I think as you rightly put it, it is a shared responsibility, and so we are certainly doing what we need to do from the court side. We want to be fully engaged with our county partners as well.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank the gentleman. Representative Kale.
Thank you, Mr. Chairman. Thank you, Justices, for being here today. I'd be remiss if I didn't give a shout out to the law clerks within the judicial system. I started my career some 14 years ago as a law clerk for the Honorable Judge Debbie Kunselman, who at the time was a district judge, or a common pleas judge, rather, in Beaver County. And it was a fantastic experience, great way to start your legal career. And I hope, I don't want to ask this question, but I hope they are getting paid more than we were getting paid 14 years ago. But judging by the conversations today, I have my concerns. The actual questions I want to get into, your budget narrative mentions the Supreme Court's creation of an Artificial Intelligence Advisory Committee to study responsible use of AI in the unified judicial system. Could you say what type of advice has the committee offered, and where are we at with these matters?
Thank you, Representative, for that question. I'm really honored to be chairing our court's Artificial Intelligence Advisory Committee, which is a 14-member group representative of the appellate courts, the common pleas courts, the magisterial district judge courts, court administration, county filing offices, and our Rules Committee. When the court established the committee in the summer of 2024, we got right to work. I think the court was rightly concerned, as was I, about the void of guidance. We were starting to see a number of state Supreme Courts and state court systems make sure that people weren't acting in the void, in particular with respect to generative artificial intelligence, which has made up so many headlines, hallucinated cases, and whatnot.
God bless you.
So the committee did submit a proposal to the court in terms of interim guidance on the use of Gen AI by judges and court staff. That was adopted by the court in September 2025 and went into effect in December. And the highlights of the policy are this. Be careful when you use Gen AI, because we want to make sure that Gen AI is used in a safe and responsible way to protect the integrity and the impartiality of the judiciary. Gen AI is permitted to be used when designated by leadership of a court. That would be a president judge, or in the case of AOPC, that would be me. And you are allowed to use Gen AI non-secure systems. So that's basically, ChatGPT or whatever you get on your Dell computer when you buy it from Best Buy. You're allowed to use ChatGPT to do initial drafts of correspondence, to summarize documents, as long as what you're putting into the Gen AI tool is public information. We want to safeguard the vast amounts of non-public information that the courts deal with. And so those are only allowed to be in secure systems. Now, secure systems are basically large software licenses that are bought. I'm just going to use the AOPC as an example. Our Microsoft licenses are set up through our IT department. And so our IT department is in the back with our legal department, making sure the terms and conditions of the contract are just so, and all the right levers are switched in the right way. We don't have secure systems at the AOPC yet, and we don't because the cost is, it is literally doubles the cost of the license.
I appreciate that answer, and I have a overall concern with artificial intelligence within the legal community broadly. And I'm curious, is the Supreme Court considering new ethic rules as it relates to artificial intelligence usage by litigants, by lawyers in general? I personally have concerns with basically the unauthorized practice of law with artificial intelligence just manipulating briefs or creating briefs or creating documents or anything like that. On that, because I see my lights coming, so I'll let you answer after. I have a twofold question. Is there a need for the legislature to offer rules in and of itself as it relates to artificial intelligence use in the legal field?
You might get two different answers from two different justices on this, and I just spoke about this at the County Conference of Bar Executives in State College. And I'm old enough, you're not, I'm old enough to remember when email came out and when Westlaw came out and when all the lawyers were panicking about the fact that the West books, you weren't going to be able to take them off the shelf anymore and things like that. Westlaw was its own version of AI in the time, and some longtime practitioners were making the same arguments about Westlaw that they're making about generative AI right now. I think generative AI is here to stay. I think it's an incredibly powerful tool. Particularly for pro se litigants who can't afford attorneys. They can use generative AI to create somewhat of a readable document, although we do get some good pro se people. Whether we're going to go down the road of adopting ethics rules and things like that, I think there will be discussions about this, but I would say this. The same rules apply to a lawyer who's using generative AI that applies to a lawyer that isn't using it. When you sign your name to that document, I am assuming, as an officer of the court, you are representing to us that you have reviewed it, it represents your work, and you stand by what's there. Whether, and I've been around, Justice Doherty's been around for a while. I had plenty of briefs when I was on the Commonwealth Court where lawyers would cite cases that didn't say what they said, and where lawyers would cite cases that didn't even exist. Hallucinations happen before generative AI, and they're going to happen afterward. And I think the bottom line is, if you were a lawyer and you put your name on a document, it doesn't really matter to me much whether you use generative AI or you used an associate. I expect you to stand by that work product, and if it's not up to snuff, you're going to hear about it.
Right now, I think what we're just doing is we're updating our verification form. If you remember it, you just have to sign all your pleadings are true and corrected. Now we're just adding the language, if you use artificial intelligence, that it has been in fact verified. And I just recently, there was a judge, a federal judge, who just held a lawyer in contempt for submitting briefs. And they were hallucinated briefs based upon cases that didn't exist. So I am the side of Justice Brobson that disagrees with them necessarily. I do have a concern about it, and its use, very similar to you. I think it can be abused when we are handling our cases and we're reading box-filled of briefs. I could tell you my law clerks and I are not shepherdizing each and every one of those cases. So we do have to have some element of ethical concern or consideration with regard to a lawyer's submission.
Thank you. Thank you for being here today. Thank you, Mr. Chairman.
Thank you, gentlemen. Chairman Struzzi.
Thank you, Chairman Harris. So just want to reiterate some of the numbers that I mentioned earlier. The governor has proposed general fund appropriations for the judiciary of roughly about $500 million. I may have said 50 earlier, that's somewhat off, but clearly $500 million. But the judiciary, your initial request was for $518 million. So essentially, the governor's proposal underfunds the judiciary by about $18 million. As we saw this morning with the Attorney General, similarly, the proposal that the Attorney General put forward was $19 million more than what the governor is proposing as his spend number. Now, obviously, we're concerned with the overall spend, but as I said earlier this morning, I think that the fundamental nature of what we do is to make sure that law enforcement and the court system are adequately funded. Yet, the spending proposal put forth by the governor underfunds judiciary or courts by $18 million and the Attorney General's office by $19 million. My question, though, is if you do not get that additional $18 million that you have requested, what are the consequences?
I think, Chairman, I think there's fiscal cliff is sometimes thrown around a little bit too much. But in our case, we have been playing catch up for several years now to try and get our general fund appropriation to where it needs to be to represent what we believe are the true costs of providing a strong judicial system to the people of Pennsylvania, that third branch of government. We have been able to do what we've been able to do with less in our general fund appropriation than we would otherwise have because of the Act 49 funds that have been available. That will no longer be the case at some point in time very soon. If that happens, there are certain programmatic consequences to that. There are real people consequences to that. There are access to justice consequences to that at our county levels in particular. We will have to make some incredibly difficult decisions that we don't want to have to make. That's why our budget that we proposed represents what we believe the true costs are, being fiscal stewards, understanding that Act 49 has a $60 million ceiling for which we can tap. We don't have any other funds that we can get to supplement our general fund appropriation. We think it's a responsible budget, and we would certainly ask that the General Assembly consider fully funding that request.
Well, I appreciate that, and as we know that this is the beginning point of budget negotiations moving forward, I appreciate you all being here today. I think, though, fundamentally we should be funding law enforcement and we should be funding our court system based on your request, knowing that you know what the needs are when we don't. And I'm not making any inferences, but I think the numbers speak for themselves. So thank you all for being here.
Thank you, Chair.
Thank you, gentlemen. Justices, I do have a few questions before we wrap for today. I slightly disagree with one of my colleagues about, you guys, you know how I feel about this. I'll just say it publicly. I honestly do not believe we should be using Act 49 dollars in our budget at all. I think it is a barrier to justice, and I also believe it's a contradiction in a sense. In a perfect world, I would say we should fully fund the court, and any Act 49 dollars that are generated could be just sent back to the general fund. But for me, I just totally believe that we should not be using fines and fees to help stabilize the court system, and we should just fund the court system as necessary. If we were to do that and get rid of you stabilizing the court's budget with Act 49 fees, what would the number be necessary from the General Assembly to actually do that?
$60 million, because that's what, $60 million, because that's what we project we're going to be using in fiscal year 26, 27.
Now, is that 60 million on top of the 18 million you're asking? That is a difference?
It's in addition, well, no.
No, it's the six.
No.
It would be, Chairman, it would be our general fund appropriation request plus 60 million on top of that. That would replace what we're counting on for Act 49.
What we're
So
asking,
then that'd be 78 million? Is that what you're saying? Or am I-
578 million.
578.
So it'd be 78 million in addition to what the governor has proposed. Is that correct?
That's correct.
And then we could just send the, whatever is collected from Act 47, you guys would be in agreement that we could just send that to the general fund if we begin to fund at this level?
Statutory. That's in your, there's statutory fees, that's in your ballpark.
Fair enough. Okay. All right. Understood. I've always said that. I mean, I think, and there could be some modifications, like, filing different cases, stuff like that. But just to me, it seems to incentivize the necessity of different fines in order to help. And I think as a co-equal branch, we should just go ahead and fund the court system as a co-equal branch and just proceed from there so that access to justice is not a barrier for anyone. So that's just my personal view and opinion. And so I think we should do that. I know that you guys do courts, special sessions in the community from time to time. I wanted to ask who makes a determination for where those special sessions happen and things of that nature.
I've been on this court, this will be my 11th year, and we only did one special session, and that was in Luzerne County, and that was at the behest of our Chief Justice. We usually sit twice a year in Philadelphia, Harrisburg, and Pittsburgh.
I will say this, Chairman, and I'll shout out Judge Stabile is in the back of the chamber representing the Superior Court. The Superior Court travels very frequently into our communities. doing regular panel sessions for that court. And I know the Commonwealth Court as well, on occasion, will get invited to go to counties to sit, and I think I think that's wonderful. I enjoyed doing that when I was on the Commonwealth Court as well. So I think, kudos to our intermediate appellate courts for being out there in the communities when they can.
And who makes those decisions on those locations?
So when I was on the Commonwealth Court, it would usually be an invitation from the county bar associations, or some other person would invite the court to come and sit as a special session. And assuming it could be fit into the court's schedule, there were very few times where we declined the request.
Really?
Yeah.
So let's say Cheney University, the nation's first HBCU, wanted to have the Superior Court or the Common Pleas Court have a special session there. How would they go about that?
I would suggest that Cheney University write a letter to the president judge of both or either courts and invite them to do a special session at the university.
Really? Or Lincoln University?
Or Temple.
Or Temple.
Yeah. I love Temple. Don't take it, but
Go Owls.
Okay. Will they be here next week? Okay, Temple will be here next week. But I'm just, I ask about that because these are historically black colleges and universities. Quite honestly, depending on who you ask, one's going to say one's the first, the other. I typically don't get into the Cheney-Lincoln argument. I will say, though, both have historic reputations. I think Thurgood Marshall went to Lincoln. I just think it would be amazing to have one of our courts sit on the same campus that the first African-American Supreme Court justice of this country went to. I just think that would be a phenomenal experience for all of us to have something like that on the campus of Lincoln University.
And I'm sure that chairman's letterhead would be very helpful in the letter sent to that.
You said it, I didn't, but okay. I'm just saying, the more we can, here's the thing, the more I think we get our courts into our community, I think it just builds on more folks understanding and knowing and trusting and wanting to be involved. And I'm a former school teacher, and I've said this before. There is something special about that moment that a young person gets it, understands, and it's like an illumination. And it's really like you do see a light go off in their head. And I just wonder how many young people, if they were actually able to see what you all do every day, how many young people would say, you know what, I've never thought about this, but this could be something I want to do. So just that. And speaking of that, internships in the court system, is there a central coordination for that? How does that work? I don't even know if you do. Do we do internships? How does that work? Where do we look like for internships to get?
Well, I could share with you, the FJD, the Philadelphia system, has its own internship, and there's a particular Common Pleas Court judge that's assigned. I participated in that for the 15 years I was in Common Pleas. The Supreme Court, we do have summer internships.
Okay.
And I'd have to find out. We usually get referred by the Chief Justice will tell us there's summer internships, and it's usually by word of mouth.
Okay. I would ask if, whenever that happens, if you could let us know. Chairman Napoleon Nelson's not here, but he chairs the Pennsylvania Legislative Black Caucus. I would be very interested in seeing what we can do to make sure that we're getting it out so that we can have a diverse pool of candidates, so that we can open and expose more of our young people. I would even also, I don't know if there's a rural Pennsylvania group, but I would even wonder, because I feel like I'm from Philly, I'm from Pittsburgh, I feel like we know and have access to a lot of these things. Some of our folks in rural Pennsylvania, some of those young people, I think, would be extremely interested in internships as well in our court system. So if you could share some of that information with us, we would be glad to help promote that kind of stuff as well.
Fair enough. Thank you,
Chair. Did that. Yeah, I did. How are we working with my favorite topic to talk about, clean slate? How are we working with clean slate currently? I know in the past we've had some work that we needed to do with the FBI and with the state police and who work through those problems. where are we now with Clean Slate?
The AOPC, and the court very much appreciates the partnership with you, Chairman Harris, on this issue. It's been incredibly successful. We've coordinated with state police and Board of Pardons doing the significant recoding and reprogramming that's been necessary under Clean Slate 1, 2, and 3 at a cost we estimate of $6.2 million to the judicial computer system, which we absorbed. As from my vantage point, we have implemented the acts fully. If there are issues that you are concerned about or that there are other, constituencies are concerned about, we're always welcoming of a conversation.
Well, look, I take a point of personal pride. Myself and my colleague, Representative Delozier, have been at that work on Clean Slate. Now, this is 2026, about 10 years, and I think we're up to 55 million.
57.6 million cases as of January and over 82 million offenses. And none of that would have been possible without the judicial computer system. In fact, I just learned last week that Illinois passed its first Clean Slate legislation.
Wow.
And because they don't have a statewide system, they have appropriated $18 million just to get that first phase done.
Wow. I feel like that was a request for money on the slide, but I'm picking up what you're putting down. But no, seriously, it's I think been widely successful and something that people all over the country are following. And it would not have been possible without the partnership that we have with the judiciary, you and all of the other folks, Damon, who I'm sure I've called more than he's wanted me to over the years. But we've been able to do what I think has been extraordinary in helping people every single day. So I thank you for that. And with that, I am finished, and I think that will conclude our hearing today with the judiciary. And we will be back here tomorrow at 10 a.m. for our hearing with Labor and Industry. And with that, I thank Justice Doherty, Justice Brobson, our court administrator, and all of the members of the judiciary for being here with us this afternoon. This will conclude our budget hearing with the judiciary.